Introduction to statutory demands. COVID-19 and the Corporate Insolvency and Governance Bill referred to in this video are leading to regular changes, often without notice. Even in the continuing pandemic, we are finding that statutory demands are continuing to be served and remain an effective tool if or where any creditor is clear on the consequences of their use. In this fast-changing environment, before taking any steps, you should check the most up-to-date position with a solicitor. The Corporate Insolvency and Governance Bill 2020 and the Corporate Insolvency and Governance Act 2020 have introduced temporary measures to protect companies struggling as a result of COVID-19. These measures, applicable from 1 March 2020, have been extended until 31 March 2021. This legislation prohibits a winding-up petition being brought between 27 April 2020 and 31 March 2021 if the petition is based on a statutory demand served between 1 March 2020 and 31 March 2021. This can provide a useful tactical defense, as well as the threat of seeking recovery of costs. The legislation also prohibits the presentation of a winding-up petition unless there are reasonable grounds for believing that COVID-19 has had no effect on the solvency of the company, and that the debt would have arisen anyway, known as the coronavirus test. The court cannot make a winding-up order on petitions that fail the coronavirus test. Statutory demands are not a debt recovery procedure, but they are often misused as such. Properly used, a statutory demand is a way to prove that an individual or a company cannot pay their liabilities as they fall due and are therefore cash flow insolvent. Proving insolvency is necessary if the creditor wishes to petition for the individual's bankruptcy or the company's winding up. Failing to appreciate that a statutory demand is not supposed to be used as a debt recovery procedure can cause significant loss to a creditor if the demand is disputed. If the creditor serves a statutory demand for a disputed debt, or refuses to withdraw it if a dispute is raised after it is served, then the creditor may have to pay the debtor's legal costs for setting aside the statutory demand against an individual or for an injunction preventing the presentation of a winding-up petition by the creditor. The costs payable by the creditor on setting aside or the granting of an injunction can range from £2,000 upwards even if, ultimately, the debt is owed. It is important for a creditor to realize that withdrawing the demand is not an admission that the debtor does not have to pay but is merely a recognition that there is a genuine dispute or triable issue for a court to decide. There is no point wasting time and money defending an application to set aside if there is a genuine dispute. The creditor is better off applying its time and money to pursuing the relevant pre-action protocol and, if necessary, issuing proceedings. There is a second problem. What happens if the demand is not challenged and no dispute is raised? The creditor's next step would be to initiate formal insolvency proceedings by presenting a bankruptcy petition or winding-up petition. That will cost at least £2,000 and then the creditor will have to share any net assets left after the costs of insolvency with the other creditors. At Helix Law, we are happy to have an initial conversation with you. If you have any queries, contact us today to book an appointment. For more information on statutory demands, visit our website.